Hello, my fellow Alaskans. How are we all doing this bright and beautiful? It's getting pretty dang dark out there Thursday night. A little bit on the chilly side. I hear the cold temperatures are about ready to roll in, and we are just about ready to begin the live stream rebroadcast of their stream of Alaskans for Constitutional Rights. They will be presenting again tonight the author and forensic journalist David Ignell, and talking about his book, Alaskan Grand Juries. I believe they're still in chapter 10. It will be in the second half of his book. If you are interested in anything that is going on, especially for the Alaska Grand Juries investigations that are going on in the Kenai Peninsula area and have taken a statewide notice out there of what is going on, I'm sure you are kept up to date on all the latest and greatest information. If not, what is stopping you? Just go to AFCR1776.com. That's AFCR1776.com. Get all the latest, greatest information about what is going on there. And Alaskans for Constitutional Rights, you can find all the information there for all the things that are happening in different areas. Or you can contact David Haig directly. I'm sure you can find a couple of videos on my page. Just type in his name, David, H-A-E-G, Haig, and you will be able to pull him right up. And you'll be able to find usually all of his contact information. I try to keep it there. Again, their broadcast is about ready to begin. I am keeping check on their pages right now. It's supposed to be every Thursday night. I didn't hear anything different about it not being tonight, so we're just hanging out here. For your FYI, tomorrow they are for Senate Bill 14, the RIP bill, R-I-P bill. This bill is for the retirement incentive program. It begins out reading like, here we're going to bring retired teachers back in to start teaching again. We'll allow them to continue to collect their retirement benefits that they have already qualified for in the meantime for the next 4 years or so. And then the further you get reading into the bill, and this all sounds great way to replenish the workforce of teachers while they're helping to try to find other recruits to be able to take those full-time positions. And in the meantime, let those people be able to earn a lot better income out there to add on to the retirement they're already receiving, and hell, be able to maybe go take a trip around the world after 4 years of teaching again, plus receiving their retirement benefits. Well, you take the combination of the above things, it all sounds good. But after 4 years, and then you start reading into it, all of a sudden the bill brings up firefighters and police. And you're going, well, what does that have to do with this? Well, if you've been keeping track of the bills going on down there in Juneau, they got HB, House Bill 22, and that bill right there happens to be defined benefits for police officers and firefighters. And the deeper you dig into Senate Bill 14, the more you begin to realize this is just a way to bring defined benefits into the hands of all of those out there that wish to be able to control what they are receiving there for money for their retirement. And the HB 22 even says that they can retire with full bennies at the age of 50. Now, we almost bankrupted our state the last time something like this had passed, and this is a way the Senate Education Committee is trying to sneak this bill in by saying it's for the teachers. And but they are taking public testimony on it tomorrow. I believe it starts at 3:30. And please call in and tell them hell no to Senate Bill 14. This is just more money being funneled into a program that can't be afforded or paid for. Every time they try to do defined benefits, it did one thing: it bankrupted our state. We're still almost $4 to $7 billion in the hole for what they're supposed to have already been paying. I just saw that their live feed just came live. Let me do some screen switching here. Do a little refreshing, get it up on the screen so that we all can watch. And give me just a second here and we'll have this all up and rolling. Ooh, I hear them in my ears, so that is a good sign. I've already got the screen captured. Let me get my face out of the view here. And you guys don't forget, like, share, find this on Twitter, YouTube, Facebook, all at Politadick. Find it on Rumble in the next 6 hours, and go to our website, politadick.com. You can find it live and click that support button. Help us grow.
I just want to welcome David Ignell again. Thank you so much for coming back for another round. I think we're on chapter 11.
Yes, we are, Chandra.
And I'll just let you take it away.
You bet. Well, thanks for having me back. It looks like got a pretty good sized crowd in person today at the at headquarters there. So we are on chapter 11. The next two chapters we're going to be talking about Criminal Rule 6.1. This was I think a lot of people are, have heard about 6.1 recently because that's what was amended in Supreme Court Order 1993, which became effective December 1st. But when I wrote my book, obviously no one in their right mind would have probably predicted that SCO 1993 would become a rule. But as they say, desperate times call for desperate actions, and that's what I think Supreme Court Order 1993 was. But what my book addresses in the next two chapters is the original Rule 6.1. And this affected the grand jury's reporting powers. As we saw in the last chapter, chapter 10, after the Sheffield investigation and the resulting, Senate, giving him a pass, all 20 senators ganged up on the grand jury and made they asked the Alaska Judicial Council to do a recommendation on, trying to curb the reporting powers of the Alaska Grand Jury. But, as we covered last week, all 20 senators knew that a constitutional amendment was required to do this. So, they passed a resolution asking the Alaska Judicial Council to take a look at this issue and see if the reporting powers could, how they could be curbed through a constitutional amendment. So it goes, the issue is out there. And so chapter 11, we're going to be looking at basically two reports that follow the Senate resolution. And if you go to the first page of chapter 11, this is page 90 of my book. The first report that I address is a 1986 article in the Alaska Law Review, and it was entitled "The Reportorial Power of the Alaska Grand Jury." Now, this was a 36-page article, so they got into this issue in depth. And the Alaska Law Review is actually published through Duke University Law School in North Carolina. I think that's still the case today. I think that there's been some kind of relationship between the Alaska Bar Association and Duke Law School. So this is the official, as many of you know, Alaska doesn't have a law school. This is one of the reasons why I ended up in California, because I had to go there to get my law degree. So this is, this is a very authoritative source. So anyway, they took a look at this issue. Can the reporting power of the grand jury, can that be, restricted? And so they cited the Camden case. Remember in chapter 7, we went over the Camden case in detail. That was Judge Vanderbilt's 1952 opinion, in which he said the grand jury was of such importance to our government that, you know, he wanted to go back and start from the beginning of common law and trace its development. So repertorial power, and the Camden case had been attacked by Sheffield's lawyers. They said it was overruled. They said it was bad law. And so the first thing repertorial power did is they said, no, the Camden case has not been overruled. It's still good law. And then repertorial power did much like what my book did. You'll see this in the, I guess, the 4th paragraph down, where I say, you know, much like this study has done, repertorial power stated that, quote, an examination of the historical development of the functions of the grand jury is essential to understanding how the grand jury should operate today. That's a critical quote by the Alaska Law Review, because they're saying that what we have been doing for the last 10 chapters is exactly how we're supposed to do this. We're supposed to look at the common law, the historical development, the common law functions of the grand jury. That's essential to understanding how the grand jury should operate today. So, you know, that's an important quote. And then repertorial power goes on, you know, after doing a summary of the common law development in England, colonial American, and finally Alaska, they talk about this argument that was advanced by Sheffield's attorneys, saying that the reporting power of the grand jury should be limited. And repertorial power stated, quote, the historical development of the grand jury weakens the force of this argument. So, you know, right there, they're disagreeing with Sheffield's attorneys. And one of the things that they pointed out, and this is at the bottom of the page, I write, this is the very last sentence on the page of 90, I write, in discussing Mr. Buckaloo's opposition to the expanded powers suggested by Mr. Barr, repertorial power correctly noted that, quote, Delegate Buckaloo apparently believed that his concerns about the amendment were not abrogated, because he was one of the 8 delegates who voted against the amendment. And if you'll recall, when we discussed chapter 8, we discussed how Mr. Buckaloo was the only one of the 55 delegates who voiced opposition to the expanded powers of the grand jury that were suggested by Mr. Barr. And so repertorial power points this out as well. Let's see here. And then over on the next page, at the top in the first paragraph, repertorial power actually attached an appendix to their report, which had the minutes of the proceedings of the Alaska Constitutional Convention. And it contained that entire dialogue of the delegates on this issue, and the identity of the yeas and the nays in the 44-8 vote. So again, this is something that I've covered in chapter 8 of my book, and repertorial power did the same thing in establishing that the reporting power of the Alaska Grand Jury could not be abridged. Then repertorial power went on to do a survey of the relevant law in other jurisdictions. And they found that in 24 other states, grand juries had the authority to issue reports that are critical of specific individuals. They cited in particular to Nevada, which the article said has a grand jury statute that is quite similar to the grand jury provision in the Alaska Constitution, and judicial decisions in Nevada have held that the grand jury may issue reports naming specific individuals. So this was more evidence for the law review people that yes, Alaska grand jury reports can identify specific individuals who have erred in what they've done. And so down to the next paragraph, the law review wrapped up its analysis, concluding that because of the shall never be suspended language in the Alaska Constitution, quote, any reform measures adopted must not suspend the reporting power. So again, they're saying the same thing. If you want, if people in Alaska want to have the reporting power of the grand jury limited, it's got to be a constitutional amendment. It can't be any other way. And then the last thing I want to say about repertorial power is in the next paragraph, because what they said was important, and I'm going to quote the last two sentences here. This is towards the bottom of page 91. The law review article said, however, granting the grand jury the power to investigate and make recommendations implies that the grand jury should be the body that evaluates the evidence disclosed by the investigation. Then allowing a trial judge to reweigh that evidence and perhaps to suppress the recommendation would usurp the grand jury's power. It would appear that such a level of review would contravene the suspension clause. And what we're going to see, later on in the next chapter is Rule 6.1 did exactly that. It allowed the trial judge to reweigh the evidence and perhaps to suppress the recommendation. We're going to see that, I think, in the next chapter when we discuss a case out of Anchorage, which involved the sex scandal involving a teacher at Bartlett High School, where the Supreme Court reweighed the evidence and they suppressed a lot of the report. So that's enough said about repertorial power. So now we're going to go to the second report that the rest of my chapter deals with. And this is the report that was put out by the Alaska Judicial Council. Okay. These are the people that select our judges. Now, one thing that you're going to find of interest, so the 3 months after repertorial power was published and 18 months after the adoption of Senate resolution, the Alaska Judicial Council comes out with this 58-page report. So interesting about this is the Alaska Judicial Council just kind of ignores what repertorial power has just said. I mean, they just skip over that. And their report is 18 months after the Senate resolution. So they've been looking at this 18 months, which tells you something. It tells me that there's controversy going on behind the scenes. Much like I think what we've seen a little bit in Supreme Court Order 1993, where the Rules Committee is going, hey, wait a minute, there's some constitutional issues here that we need to discuss and we shouldn't rush. Well, what we're going to find out later in the next chapter is that two of the judges on the Alaska Supreme Court said that this Rule 6.1 was unconstitutional. And so there was a lot going on behind the scenes. And when I requested my Juneau grand jury investigation this fall, this is something that I wanted the Juneau grand jury to look specifically at. So I know right now that some of you are trying to, get the Kenai grand jury or other grand juries to investigate Supreme Court Order 1993. if we get that off the ground, let's make sure we go back and also investigate, this original Rule 6.1, because I think there should be a ton of documents. The people that were involved, most of the people involved back then won't be around, but there's going to be a document trail here that's going to show. I think it's going to show the two Supreme Court judges, telling the other three, look, you can't do this. This is unconstitutional. And so if we do get a grand jury to investigate the Supreme Court and the Alaska Judicial Council, let's not forget this. So here's something that I think most of you are going to be interested in. So Marla Greenstein, she was the research attorney on the report. If you go to that report and download it, you'll see her name on the first couple pages there. And she was the research attorney, which meant that, she probably had a major role in researching the law and, and the cases that they were citing. So now going on to the next page. At the top of page 92, I start by saying, to the council's credit, their report acknowledged several important functions of the investigative grand jury. And I'm going to go through and describe some of those that they did. But, it kind of reminds me of a bait and switch, like when a salesperson tells you a lot of good things about a car or something, and then they put you into another car, they get you going. When I read the report, it's kind of like this, because they say some really good things in the beginning of this report. You're reading it and you're going, yeah, that makes sense. That makes sense. And then just kind of buried in this thing, they ultimately come out and they recommend an unconstitutional rule, ignoring everything that they just said. It doesn't make a whole lot of sense. But going down to the second paragraph, I want to read some of these things that came out of their report. So the first thing they said is the investigatory and reporting power of the Alaska Grand Jury is broad and covers virtually everything of public concern. It can't be hindered or delayed. So, there's some important things in there. They're saying it covers virtually everything of public concern. And they're not only talking about the reporting power, they're talking about the investigatory power. So, compare that with what we're dealing with 1993. Back in 1987, even the Judicial Council is saying they can basically investigate everything of public concern. And that investigatory power can't be hindered or delayed. But yet today, that's what they're doing. The next point down. The grand juries of England and of the colonies generally acted as, quote, spokesmen for the people, sounding boards for their leaders, and vehicles for complaints against officialdom, unquote. So again, that's what we've covered in chapters 1 and 2 when we went over the common law grand jury of England and how the colonists brought it over to America and expanded it to civic use. And so for them to say that the grand jury is the spokesman for the people, sounding boards for their leaders, and vehicles for complaints against officialdom, and then you look at Supreme Court Order 1993, there's a disconnect there. So again, this is another important admission by the Judicial Council that flies in the face of what the Supreme Court and the Attorney General are trying to do today. So then the next point, and again, this comes right out of, and it's an admission by the Judicial Council, it says the investigatory powers preserved by the Constitution particularly apply to investigations of public officials. And then later on in the report, the Judicial Council suggests the grand jury may have a special responsibility to monitor the courts of justice or other public offices citing to Alaska Statute 12.40.060. So again, compare that admission back in 1988 or 1987 to what's going on today when, in Kenai, you all have been trying to get investigations into public officials for the last 5 years. And they even admit that the grand jury may have a special responsibility to monitor the courts of justice. So everything that your district attorney and your judge have been doing up there for the last 5 years are illegal. And there's the proof for it. Then on the last point here. So just as grand juries in Alaska are constitutionally empowered to investigate any matter of public concern, so are they free to report on their findings. Moving on down, on the issue that had been posed to them by the senators to curb the powers of the reporting powers of the Alaska Grand Jury, their report had the following statement. The limitations on report content that exist in other states in the federal system are based on far more restrictive grants of constitutional and statutory authority than are found in the Alaska Constitution. The adoption of substantive limitations in Alaska would therefore require constitutional amendment to restrict the subject matter of investigations, to limit the purpose of reports, or to otherwise effectively suspend the recommendation power of the grand jury. So you read that and you go, how could they ever enact Rule 6.1 back in 1988? And now the amendments to 6.1 that are embodied in Supreme Court Order 1993. And they even admit here that you can't compare the powers of the Alaska Grand Jury to those in other states in the federal system, because they're admitting right there that those other states have more restrictive grants of constitution and statutory authority than are found in the Alaska Constitution. So, but yet what do they do in this report? They cite the federal practice. It just makes no sense. So then okay, so I'll go to the next page now. Turning over to page 93. They also, the report talked about the procedural process of launching a grand jury investigation. So I brought these out of my book, and they're particularly important to Supreme Court Order 1993. So the first point, the Alaska Grand Jury can investigate potentially criminal or non-criminal public welfare or safety matters on the request of the court or the district attorney, or in response to petitions or requests from the public, or on the initiative of a majority of the members of the grand jury. So this is what we've been studying throughout my book, is that anybody could come to the grand jury, petitions or requests from the public, and they could ask the grand jury to investigate. It said they could investigate on the request of the court. I mean, when I tried to get my grand jury off the ground in Juneau, the judge told me in a letter, I've got it in writing, that she could not read my petition because Rule 6.1 prevented her from doing that. So, this was back in September that she told me that. So what she said completely flies in the face of what the Judicial Council is saying in their own report back in 1987. And then the issue about petitions or requests from the public. Thomas Garber, he petitioned the court for a grand jury investigation into the OCS. And that was stopped by SCO 1993. David Haig and Ray Southwell, their requests for grand jury investigations have been stopped. So, clearly these Supreme Court orders are unconstitutional. They break the law. They're illegal. The next point that was in the Judicial Council's report, and again, this isn't talking about the reporting power of the grand jury. This is talking about the procedural process of launching a grand jury investigation. So the next item says the grand jury clearly has a duty to investigate matters coming to their attention independently of the prosecutor, citing to the oath taken by grand jurors. And we have covered this in chapter 8 when we talked about the Alaska Grand Jury, and we talked about the oath. And there's a duty. It's not elective. If a grand, and this was the same thing back in common law that we studied in chapter 1 in England, grand jurors had a duty to investigate matters under their oath. And again, our oath in Alaska is very similar to the oath that was taken in England 500 years ago. So here's another admission by the Judicial Council that everything we're trying to get off the ground with respect to grand jury investigations this year is appropriate. And then the last point that they admitted, they say in the case of major investigations, a special panel can be requested. And this is what I did in my Juneau grand jury request. I said, I was like, look, this is extensive. This is going to take a long time. And so, and a lot of focus. So we need to have a special panel appointed. And I would hope that in Kenai, I guess nobody knows where the grand jury investigation is currently, but I would hope, and if anybody, hearing me talk tonight, knows any of these grand jurors, to say, look, if you guys are concerned about the stuff that you are digging into, but don't feel that you have enough time or don't have the resources, ask for a special panel. Again, the authority is right there in the Judicial Council's own report. So moving on, my next paragraph, I talk about how, you would think that after all these things they said about the grand jury, they would stop right there. They're like, hey, okay, legislature, here's proposed language for a constitutional amendment. But they didn't do that. Instead, as I talk about in the next paragraph, they recommended the adoption by the Alaska Supreme Court of extensive court rules that would have to be followed before a grand jury report could be made public. And pages 4 through Roman numeral 6 of the report's executive summary set forth proposed criminal rule 6.1 for grand jury reports. Now, basically, those proposed criminal rules were from the federal courts, and we just covered that a little bit ago about how the Judicial Council said that the constitutional authority for grand juries in federal courts was less than Alaska courts. But here they're recommending federal rules. So it's bizarre. There's absolutely no basis for it. So at the bottom of I'm not going to go through, and my book doesn't go through all those rules. It was maybe 2 or 3 pages of rules under 6.1. But the big change, or for reporting purposes, the new standard was that the report had to be supported by substantial evidence, and the report could not infringe upon any protected rights or liberties of that person. But the problem here is that it required the court to find these things before the report could be released. So, and we just covered that earlier in this chapter, where we talked about there was the one quote, I think, in Repertorial Power, which said that it's not for the court to decide the evidence. It's the grand jury that's the decider of fact and evidence in these things. So these these proposed rules really limited the power of the grand jury. It now, instead of the grand jury being the finder of fact, it was now putting that back into the hands of the court. The court would have the ultimate say. And again, this is something that in the Juneau grand jury case in 1985, Judge Pegues, we went through his quote when we covered chapter 9, and he said, "It's not for me." He says, "I may disagree with the findings of the grand jury, but," he said, "that's not my role. The role of the fact finder here is the grand jury. And even though I may disagree, my opinions don't matter." And so here we have a monumental shift in undermining the power of the grand jury. So, and here's where this plays out in as an example how this would have really played out to the detriment. I mean, so imagine if this standard of needing to be supported by substantial evidence. I mean, what's substantial, right? I mean, that's a pretty debatable. It's hard to measure. What is substantial evidence? What's substantial to one person may be non-substantial to another. And you see this in you start thinking about, okay, what if Governor Sheffield, what if these rules had been in place when the Juneau grand jury investigated Sheffield? And this is what I talk about on the top of the next page, page 94. I say, had these standards been in effect in 1985, Mr. Sheffield's lawyers would likely have been able to stop the publication of the Sheffield report and kept the public in the dark. The 4 Republican senators on the Senate Rules Committee had said there was substantial evidence of impeachable conduct by Mr. Sheffield, but their Democrat colleague disagreed with that statement. So what I'm saying here is that you had 4 Republican senators who look at the grand jury report and they say, well, there's substantial evidence of impeachable conduct here. But then you have the Democrat senator who says, no, this isn't substantial evidence of impeachable conduct. So even though, and going back to what we looked at last week, where the senator's own lawyer, Sam Dash of Watergate fame, he said there was some very troubling things here that the governor had done. But here now, under this new rule, you're putting everything in the hands of the judge to say, okay, is this substantial or not? So if that judge favors the Democrat side of things, maybe it's not substantial. Maybe the report never gets published. I mean, that was a real possibility, that if 6.1 had been in place, that Juneau grand jury report would have been suppressed. So then I go down, I'll read here from the 3rd paragraph on this page, the 2nd sentence. I talk about how the report went out on the proverbial limb. Without citing any supporting authority, it said their recommended restrictions could be implemented either by legislation or court rules. The council did not bother to discuss how these rules didn't qualify as a delay or hindrance that violated the Alaska Constitution. So in the legal world, when you're proposing a legal argument, you usually have to, what we do, we call it citing supporting authority, whether it's statutes or case law. So they just, after saying all these good things, the Judicial Council just jumped to the conclusion that the Supreme Court could adopt these restrictive rules. And they cited, in this report, they cited absolutely no authority for that. And they didn't even bother to discuss how these rules didn't qualify as a delay or hindrance. Now, we saw earlier tonight where the law review article, the repertorial power article from Duke University, they said something like this would delay or hinder and would violate the Alaska Constitution. So this report didn't become final until 3 months after repertorial power was issued. So for the Judicial Council not to address this issue, I mean, you could call it malpractice, you could call it whatever it was, but they were just simply picking this out of the air. It was egregious. And here's some of the other law that they overlooked. I mean, there was a lot of legal precedent out there which supported the ability of grand juries to name specific individuals in their reports. If we go down to the second to last paragraph on this page, I recount a few of those. Like back in Chapter 5, the New York Code Commission in 1849, they tried to curb grand jury reports by proposing restrictive rules. The New York legislature, said, no, we're not going to follow those recommendations. We've already talked about how repertorial power had said that allowing the trial court to weigh the evidence would contravene the suspension clause of Article 1, Section 8. Back in Chapter 6, we talked about Rocky Flats. That was that case involving nuclear waste outside of Denver, where Professor Lerner, Lerner, we covered her credentials. I mean, she was like, very, very well respected throughout the country. And she was talking about the federal rules that Rule 6.1 is based on. And this is what she says about them. She goes, quote, "For all practical purposes, similar rules have abolished the grand jury's presentment power. Such judicial discretion guts the power." So that right there wasn't addressed by the Judicial Council. And then I say in the next sentences, Chapter 12 we'll discuss next, Alaska Supreme Court Justices Burke and Compton would soon express the same concerns. So I think the Judicial Council knew that what they were recommending was flat out wrong, but they did it anyway. The case law was just too clear on this, but they just chose to ignore it and recommended that these rules, Rule 6.1, be adopted with no support for that. And so you see the same thing in Supreme Court Order 1993. You have rules that are rushed through. They basically bypassed the Alaska Rules Committee, even though 2 or 3 of those people were raising their hand, and including a judge out of Fairbanks, Judge Temple, and saying, "Wait, there's some constitutional issues here," but they just rushed it through. This is what the Judicial Council does in conjunction with the Supreme Court. They ignore the law. So let's see. Oh, and then what I wanted to talk about in the very last paragraph, here's another, this may be a little difficult to follow. I hope it's not too difficult for you all to follow tonight, because I'm kind of getting this chapter of my book, it's in the legal arguments. But another thing that I looked at was, how does the grand jury operate in criminal proceedings versus investigations? So here you have the the Alaska Judicial Council and 3 Supreme Court judges kind of going out of their way to protect politicians like Bill Sheffield. So, okay, so they're talking about how, you know, people have these due process rights and we need to protect those, but then compare that to what happens in a criminal case. And this is what, you know, in the later portions of this chapter, I talk about the Thomas Jack case. So the very last paragraph here on page 94, I say, an earlier report on the Alaska Grand Jury adopted by the council in 1975 had recognized that the prosecutor's ability to control the grand jury in criminal indictments offered almost no protection to those accused. So, and I'm going to get into more of this in the next page, but here's a thought. So here you have the Judicial Council admitting that the prosecutor has the ability to control the grand jury in criminal indictments. So wouldn't they have the same ability to control the grand jury in investigations? You know, is this what's happening in Kenai right now? Because we don't have a special prosecutor, an independent special prosecutor. You know, that was, you know, that's an interesting concept. So going over to the next page, I kind of elaborate on this point at the very first paragraph of page 95. I go, it's hard to comprehend how the Alaska Judicial Council, which calls itself an independent citizens committee, could be so concerned with the protection of public officials, yet so disinterested in the protection of Alaska citizens falsely accused of crimes and denied their constitutional rights. And then I go on to talk about how, you know, you compare the protections that were given to Mr. Sheffield with those that were denied Mr. Jack, who had all kinds of exonerating testimony in his favor that was suppressed by the prosecutors before the grand jury. But yet, when this went to, and I see where I'm gonna wrap this up. I had a little bit more that I wanted to say, but I'm gonna wrap this up so we can open it up for questions here. But I just, you know, Mr. Jack's case his appeal centered a lot on the withholding of evidence from the grand jury. And it went before the Court of Appeals, and the 3 Court of Appeal judges didn't have any problem with the exclusion of evidence from the grand jury. And then it went to, he tried to appeal to the Supreme Court, and they refused to take the case. So basically you have all 8 Alaska appellate judges didn't have any problem when the Juneau grand jury indicted Mr. Jack on only one side of the story and blessed the prosecution's exclusion of substantial exonerating evidence. But yet, you know, they're talking out of both sides of their mouth, because then when it comes to protecting public officials, they're saying, oh no, you know, this has got to be reviewed by a judge. So there are just substantial fundamental problems with 6.1. So I'll skip. There was a really interesting quote that they came up with from these commentators in New York, and I want to spend a couple minutes on this, because they talked about what happened in Kenai with Ray Southwell. So let's go over to the top of 96. I'll conclude with this. So this is a quote from that was in the report, and they say, one Alaska statute provides that, quote, if an individual grand juror knows or has reason to believe that a crime has been committed which is trialable by the court, the juror shall disclose it to the other jurors, who shall investigate it, unquote. This provision suggests that an investigation might be initiated at the request of an individual grand juror. So let's just stop right there and think about, for those of you who are familiar with Ray Southwell, So back, I think it was in 2018, Ray was serving on the Kenai Grand Jury. And he was aware of what was going on in David Haig's case, and he was also aware of some issues with the OCS. And so he tried to bring evidence to the attention of his fellow grand jurors. And he was prevented by both the judge and the prosecutor from doing that. So, so right there, I mean, the Judicial Council is saying this provision suggests an investigation might be initiated at the request of an individual grand juror. Well, the judge and the prosecutor didn't let them do that. And so, but the Judicial Council is actually laying the foundation here, and in the rest of this quote, they are laying the foundation for SCO 1993. Because it goes on, legal commentators Frankel and Naftalis caution against such practice. I've got a footnote in my book. Frankel and Naftalis, they were like New York City. Frankel was a lawyer in New York. He had been a judge, and he had some controversial things happen to him. And he wrote he wrote a little treatise. Then I'll continue here. They go, speaking of the earliest grand juries, they remark, quote, drawn from the rural neighborhood in which they sat, the grand jurors themselves were primarily sources of evidence, reporting and acting on things they knew firsthand or had heard, including rumors and gossip. The commentators add, quote, today in the swirling anonymities of the great cities where grand juries mostly sit, it would be the rare and indeed somewhat questionable case where a grand juror acted on anything within his personal ken rather than upon knowledge acquired for the first time from testimony and exhibits presented by a government lawyer in the grand jury room, unquote. So that's a precursor to Supreme Court Order 1993. They're trying to, the Judicial Council is trying to limit the flow of information into the grand jury. They're saying this has got to come from the prosecutor and individual grand jurors. You know, I mean, it's like comparing New York City to Sitka or Ketchikan or, you know, small communities all throughout the Alaska. It's just crazy. So I'm going to wrap it up right there and open it up for questions.
While people are getting their questions in, I had one because I'm reading along with you here, and am I getting this right that rule that they made was made while that grand jury was sitting and they were investigating Governor Sheffield? Is that accurate?
No. So the grand jury finished the Juneau grand jury finished their investigation in July of 1985. And it went to the Senate, and the Senate concluded in, I think it was August 5th. August 5th is when the Alaska Senate decided not to impeach. They voted not to impeach Bill Sheffield, but they voted 20-0 to ask the Judicial Council to look at constitutional amendments to curb the reporting power of the grand jury. So that all happened in 1985, and this report happens in 1987. So, and this is what I'm saying. If this Rule 6.1 had been in place in 1985 when Sheffield was investigated, that report probably never would have seen the light of day. And remember, all 15 Juneau grand jurors felt it was important that Alaskans understand the corruption that was going on inside the executive branch. And they made sure, they told the judge, we do not want to be excused until this report is made public to the people of Alaska. And then we also talked about last week, you know, how some of the grand jurors felt so good after, you know, when it was all said and done. They felt that it was worth it. They felt that they had done something that was important for the state. And so, yes, but what we're going to see now in the next chapter is that these rules are put into place in 1988, and they're going to get tested for the first time, and really the only time, in 1990 during the Bartlett sex scandal case. And in that case, the Supreme Court used Rule 6.1 to withhold the truth from the public.
Okay.
And it's been the same ever since.
So then we are getting a question from there in the room. Who comprises a special panel?
Well, anybody. I mean, in a way, the Juneau Grand Jury was a special panel. I mean, I haven't been able to see all the documents on that, but it looks to me like they were a special panel and they focused solely on the Sheffield investigation. And, you know, they met for 10 weeks. They interviewed the 44 witnesses. You know, they were a special grand jury. Like, you know, you'll see examples in the news today, like down in Florida. We talked about this a few weeks ago, where Governor DeSantis has, you know, he requested a special grand jury to investigate COVID and the vaccines. And, you know, Chandra, I know that you're very interested in that. But yeah, there's been you know, a special grand jury that's been appointed just to look at that. Same thing in Georgia, you know, with the investigation into the interference into the election, you know, by some of the Trump camp. That's a special grand jury. They're looking just at that. So it would be, and so in looking at the Juneau grand jury as an example, you know, they swore in the grand jurors. And then the prosecutor went to them and said, look, you know, here's some of the people that I am going to be calling as a witness. Does anyone does anyone feel that they're going to be biased? And so, you know, he read off, I think 20, 30 names of people that they intended to, you know, bring in as witnesses. And he asked, you know, is anyone going to be biased either way on this? And no one said no, so they proceeded. But that's a very important thing is, you know, it should be drawn at random. The special grand jury should be drawn at random. And just if you're going to be investigating a single subject, make sure that no one has a conflict of interest. Make sure that no one's going to be biased. Now, there are some, you know, I didn't put this in my book, but there were a couple law review articles. I think one was from Yale, maybe one was from Harvard, where they said, well, you know, maybe special grand juries should be populated by, you know, leaders in the community, or, you know, they called it a blue chip panel, you know. And no, yeah, Chandra, you're shaking your head, because exactly. And that was the beauty of the you know, the Juneau grand jury. We went through that last week. You know, it was a mixture of you know, stay-at-home moms, teachers, nonprofit employees, government employees, private contractors. You know, just a cross section of the community, and that's what you want. And so, yeah, I hope that answers the question.
I think it just leads me a little bit, like maybe a little bit, we want to be a little more deeper of an answer. That, so for example, we've got a grand jury that that if they felt, can they ask for a special panel? Can they not just even ask for it, but demand it?
Well, you know, go back to, we've been consistent throughout the book that the grand jury can make recommendations. Mm-hmm. So, you know, if they said, look, you know, we've only had, you know, a couple months to look at this, and we strongly recommend, we see very disturbing things here. We strongly recommend that a special panel be appointed with a special prosecutor. And then that, you know, when that report is made public, hopefully, I mean, again, this is one of the reasons why I don't think there's been a lot of grand jury investigations in Alaska for the last 30 years. Because why investigate something that you can't report? And if you can't report it, how are people going to know? But you know, and this is where you have to give credit to the grand juries, like in Juneau. They said, look, Judge, we don't want to be dismissed until we know that this report's going to be made public. And so if this is the conclusion that the Kenai grand jury is coming to, that they see some really egregious things here that require, you know, which they think should be a more complete investigation with more resources. You know, again, these are grand jury. If it's a regular grand jury, you know, they're being asked to consider criminal matters. You know, any you know, criminal indictments that need to be handed down. So their attention is very diverted, and they're probably only coming in once a week. They're there for a couple hours. You know, so what I requested in Juneau, what David Haig has requested in Kenai, what Thomas Garber has requested up in Anchorage, these are detailed investigations. I mean, go back to New York City. You know, in New York City, they had these grand juries that it took them a year or two to investigate the corruption. And I think in San Francisco, when we covered that, I think there was 2 successive grand juries. You know, one investigated for like a year, and then they handed their work off to the next one to come in, who investigated another year. So, you know, these things aren't, and this is what I think, this is what I'm guessing happened to my grand jury investigation in Juneau, is they waited, and, you know, the grand jurors were impaneled for 3 months, and the court and the prosecutor waited until they were like in their last month. And then they brought my request to them, and the grand jurors, they go, we can't do this in you know, 2 or 3 weeks during the holidays. And so majority voted it down. So, you know, and again, that whole thing was tainted because the grand jury was led by the prosecutors that I was asking the grand jury to investigate. So, you know, huge conflict of interest. So does that answer your question enough, Chandra?
I think so. Yes. Yep. That's enough.
Okay.
Oh, somebody's not muted. Okay.
Yeah, it's me.
Oh, you called in. Let me unmute you. Do you want to ask a question? I'm sorry, I muted
I
you
got it.
and then,
I got it.
okay.
I got it.
You gotta mute.
Okay, do this one, just do this one.
We just go up to it.
Yeah.
Yeah.
Can you hear us?
Okay.
Yeah.
One of the things I was going to bring up in reading and what you were going through there is, and I think it's overlooked to too much of a large degree, and that is our grand juries come out, as all states do, come out of the state constitution. So there's discussions within your book here where you're talking, and it's those folks in the political arena that do this kind of talking, but they jumble things up and they talk about how things work in the federal system. Those things should not really even be talked about within the people discussing this, because as I said, all the states get their grand jury information and is based from our state constitution. That's why all the states have different grand jury setups. And so therefore, our delegates that got together and helped form our constitution, that's where the language should be directed at. And when I go through the book here, you know, I think that might have been overlooked a little bit more. Not maybe so much, you may have it in your head that way, that should have been done. But obviously the state political pundits did not view it that way. Those delegation conversations should be
And so I felt that if I wanted to have my grand jury investigation in Juneau into, the innocence of this man reported, that I was going to have to present some legal arguments. And that's why that's in there. So, I can, I see your point. It may be a little confusing, but it was to show that, you're right. And we've, I've emphasized this throughout my book and in my presentations, is that it's 100% dependent on the Alaska Constitution and the founders. That's why I devoted a complete there's, we're trained to base our arguments and our positions on solid precedent. And so for me as an ex-lawyer to read this, and it's just, it's like a fairy tale. It's made up. It makes no sense. And yes, I hope that you are absolutely right. What the founders said is being completely ignored. And we're going to see that in the next chapter. We're going to, when we look at what the Supreme Court did in this case, we're going to see, yeah, I see your hand there, but we're going to see that the two judges who dissented, who said this is unconstitutional, they went back and they quoted from the founders. And that's exactly what we need to focus on going forward. Yes, also.
Hi, it's me, Waynette. How are you?
Hey, Waynette.
Hey, so just to comment on that, last week, I guess on, maybe you read it, the article from Must Read Alaska, and it was the closing of Supreme Court Justice Winfrey, and his parting words were basically the founders even said how we are to pick the judges and so forth. So he thinks that anybody else that wants a new system is wrong. And the people have no right, and the judges are in complete and total right to do as they do. I was amazed at that comment that he actually, Winfrey was criticizing the people on his way out at his last speech, that we had no rights and that the judges were not wrong. And even the forefathers mentioned in it used their words, just like we're using the forefathers' words, that this is the way they chose to do it through the Alaska Judicial Council. I wanted to throw up, but I didn't.
Well, you raise a good point. And I've been buried in working on my next article, which is going to be hopefully supporting a grand jury investigation into the OCS. And so I've been I think I've got at least 100 unanswered emails in my inbox. But I did see that someone had sent a link to what caught my attention was Winfrey. The title to the email was Winfrey getting angry. So I go, oh, I gotta open this one up. So I did, and it was the article I think in the Alaska Watchman,
Okay.
which talked about his his State of the Union or state of corruption address to the Alaska legislature. And if anybody could send me a link to, one thing I'd like to do is I'd actually like to see, I don't know if there's a link somewhere to a video of that. I would really like to see it, because based on what I think maybe it was Joel Davidson or whoever did the article in the Alaska Watchman, but just kind of giving a summary of that account, I think Winfrey he hurt his case quite a bit by going out in that style, because I think it came across to a lot of Alaskans and legislators, much as it has to you, Waynette, that hey, this is just BS. And one of the things I want to do is, this has been on my list of things to do for a long time. If there was for at least a month and a half, there's a 1998 case where the Supreme Court, Court goes in and they interpret the Constitutional Convention, the founder statements, and they completely misquoted the delegates. And this has to do with constitutional amendments. And so the name of the case is slipping me now. It's a 1998 case where the legislature had recommended 3 constitutional amendments. And, they passed by a 2/3 vote and went to the people for ratification. But the Supreme Court held it up because they said, well, there's a difference between amendments and there's a difference between revisions. And they drug up some case 150 years old that made a distinction between revisions and amendments. And I went in and I looked at the Constitutional Convention debate on the floor. And it's what the Supreme Court is saying in that case is dead wrong. But they said it so that they could have the power. They said the only way that you can make substantive changes to the Constitution is through a constitutional convention. And that ought to tell everyone in the room and those listening why outside money spent $6 million defeating the Constitutional Convention. Because they've set it up now where the only way that you can make a substantive amendment to the Constitution is through a constitutional convention that only happens once every 10 years. So, when I see someone like Winfrey, talk like that, it just shows how lofty,
Arrogant.
Elite.
Goodbye. You're frozen? Whoops, we missed it. You froze.
Oh, I froze. Well, if it was meant to be, well, I guess it wasn't that important. So, but thanks for bringing that up, because it's a very good point and it's very disappointing. But I think it hurt the judiciary to see that kind of defiance coming from a judge, and where he's defiant towards the people. Am I freezing up again?
No.
Okay.
You're all right.
So I just think it hurt them, and it gave everybody a glimpse of just how out of touch and above the law our judicial system is. They think they can't be touched.
A quick question. So there's a limit on judges on their age in Alaska, how long they can serve. Is that right?
I've read that, but it may be 70. I know
So
I've
he
seen
just
it
turned
somewhere.
70. He just turned
Yeah.
70, and that was part of what I was reading. So if that's accurate, it's just interesting to me because legislators will legislate everybody else, but they won't legislate themselves, except for, raises and things like that.
Yeah.
Thank you, Dave.
Anyway, yeah, thank you, David, and thank you, everyone. We're just gonna work on signing off. I think this is a great
Okay.
place to end if you're good. I don't have any more questions, David. Really appreciate everything tonight. It's just funny that you're speaking to things. Obviously, we're talking about grand juries and our questions are about grand juries. And tonight you had the answers for exactly what we were looking for. So
Well, it's just,
good
it's
timing.
kind of crazy that, I look at how bad, and looking at this, this whole picture from 30,000 feet, you see what they did in 6.1 and, from a national level, from a national scale, like the gentleman just said, we got to focus on Alaska. And there was some precedent for what they did back in 1988 on a national level. But, as we've talked about tonight, that doesn't matter. But you look at what they did, there's no precedent for them to do what they're doing in Supreme Court Order 1993. To say that, if you want to investigate, you got to go through the prosecutor, you got to go through the judge. I mean, that just flies in the face of everything and there's absolutely no precedent for. So, they've gone out on the edge. They've gone out on a limb even further. And for Winfrey, going back to what Winfrey said, what Waynette brought up, because they're scared. It was interesting. Winfrey was there for that judicial council meeting in Kenai for the judge. And, I was on the phone and, so you guys got to see him in person. I don't know if was he there in person or was he on a Zoom?
He was there in person.
Okay.
Yes.
So what I was reading on the phone, he was being all calm and collected. He was kind of acting like a chief judge, just, because person after person after person is coming up and some people were attacking him. And, but he seemed to me like he was a calm and collected customer, was kind of what I was getting through the phone line. But to hear him say these things in front of the legislature, he was not calm, cool, and collected. And that's why I want to see the video on it. But
I did.
These guys are running
text it to you.
scared. These guys are running scared.
Yes, and I did text a YouTube link to you for that.
Awesome. Thank you, Chandra. I knew that somebody probably had that. Yeah, I figured I could probably find it, but I just, I keep thinking, oh, I'll have the time. And now that it's in my inbox, I'm sure I'll take the time. So yeah, I do want to see that because
40 minutes long.
Well, did he talk the whole 40 minutes?
I know at the very beginning, I mean, it's all like his entrance and everything. So you can probably skip a bit, but
all the
anyways.
pomp and circumstance.
Yeah, and the applause and patting on our backs and everything. Yes.
Yeah.
So,
well, I think they're scared, and hopefully the Kenai, hopefully the resourceful citizens of Kenai on the grand jury are going to find a way. I've got a lot of hope and faith in you guys.
Well, thank you again, and thank you everybody. Yes, Waynette's cheering. No, she says she has another question.
Okay.
No question. She's cheering. That was a cheer and goodbye and thank you. Okay.
All right. Well, good night,
All right.
everybody. All right, take
Thanks
care.
so
Have a
much.
good week.
Good night,
God bless.
David. And you.
There, now you guys can hear me. Boy, it helps if you click the right microphone. I had to walk away there. Sorry about catching a little bit late on the delay of getting everything turned off and off to the other screen. That was the Alaska for Constitutional Rights and the author and forensic journalist David Ignell talking about his book, The Alaskan Grand Juries, giving a very good breakdown on what is within his book and how it relates to our grand juries in Alaska and the grand jury investigations going on down in Kenai, Alaska right now. David Haig is a big person and advocate that is involved directly in the grand jury there and making sure the public, you, me, and everybody else gets to hear about it. You can find out more information for AFCR at AFCR1776.com. Go to their website. You can find out lots of juicy information there. You can also go to Alaska Grand Juries on Facebook page too, or Alaska for Constitutional Rights. You can find them there. There's lots of good information going on there, and also places where you can sign to repeal the ranked choice voting here in Alaska. Get that on the next ballot the next time we get to go vote. Go sign up now if you haven't already done it. Lots of opportunity to get it done. They got over 500 booklets and they've got the entire state to get covered. So help out wherever you can. All right, thank you guys all for being here again tonight, and you can find this on Twitter, YouTube, Facebook, on Rumble within the next few hours, say probably the next 6 hours. You can always find us when we're live on our website at Politadick.com, and while you're there, don't forget, click that support button. Everything you guys donate goes right back into what we're doing. We're actively trying to get more active out there into the world now that our website is back up and running again. Hopefully we can get the support rolling back in like we were seeing before it went down, and I can afford to start making more of these assembly meetings and school board meetings and stuff that is going on around our state. I have been doing a lot more of catching what is going on down there in Juneau, and speaking of that, we got tomorrow in the Senate Education Committee, Senate Bill 14, the RIP bill, rest in peace. And it's actually the retirement incentive program for retired teachers. And if you go through the bill, and I said this at the very beginning of the video, and I'm just going to repeat it now for those that are tuning in, RIP is for bringing in retired teachers that have already gone out of the workforce and have received their retirement benefits and are receiving them. And they can come back into the workforce for, say, the next 4 years is kind of the way the bill reads. Still collect their retirement, but they don't enroll into any new retirement programs. They're kind of like a sub in some ways. So they can collect a paycheck on top of still being able to collect their retirement that they already have coming in. Now, the further you get into the bill, you'll begin to see language that starts to talk about firefighters and the police. And it's really confusing when this is supposed to be a Senate education bill helping to bring retired teachers, a retention of the workforce to help build it up while they find new, younger teachers to replace those folks so that they can go back to enjoying retirement once again. But then the police and the firefighters are mentioned within the bill. And the further you get into it, the more you begin to realize, if you've been paying attention to Juneau politics, They're talking about the Defined Benefits Program, HB 22, that is working its way through the House right now. So in the Senate bill, the intent of SB 14 is to give the defined benefits that they are proposing for the firefighters and police officers to the entire educational system in Alaska. Now, mind you, the last time we had defined benefits here in Alaska, it put us over $20 billion in the hole. We're still $4 billion to $7 billion left to get that solvent to where it's actually equal to what is supposed to be in there to begin with. And that's only happened because they've retired all the previous defined benefit programs quite a long time ago, changed the tier levels, which is basically a 401k program now, and said, here you go, this is now your retirement. We'll contribute a matching set to what you put into your retirement, and that's pretty much what you're getting. At least that's the way I understand it. But now they want to give them the works. Everything you could ever ask for. I mean, everything you could ever dream for. And be able to retire at the age of 50. Okay. So now this affects you both on a municipality level and a borough level, because whatever they increase on these levels when it comes to defined benefits, now the people that are employing these folks within their boroughs and municipalities are now going to have to come up with matching funds to help out with their contributions. Well, just in the Mat-Su Valley, with the 4 to 7 billion that's still owed, the Mat-Su Valley is still currently on the hook for about 400 million, if my numbers are correct. They owe still to the benefits program that they currently have right now, and still paying off what defined benefits had created the deficit to begin with. If they kept up with it, we'd be bankrupt by now. In 1986, 1987, right in that area, our federal government, the most lunatic branch I think we have out there, well, at least one of the most corrupt, number one, and the only one that's ever second to them, of course, always happens to be Alaska. And so we have this big, huge problem, and the federal government got rid of it back then in 86 and 87. Well, and they've never brought it back. They will never bring defined benefits back because it was bankrupting our nation. And here Alaska's thinking it's just like socialism. It'll work this time. Trust us, it'll work this time. We're going to try in the House to make it just for firefighters and police officers. But here they are in the Senate, already introducing it to the educational field. So there's another 22,000 people right there to be included in that 22,000, roughly around there, for inside of the educational department throughout the state of Alaska. I could be wrong. That number could be closer to 18,000, but I'm going to stick with the 22 because that's the number in my head, and that's the one I usually repeat. But they keep floating the numbers up and down every time you turn around. Now there's 8,000 less students going to school since 2010 than there previously was. The enrollment going into schools is expecting to continue to drop because the birth rate in Alaska is not increasing. We're producing less kids, so less kids will be going to school, replacing the declining population that's already there. Kind of like our working class that we have here in Alaska. We're all getting a little aged, and we're all getting into that retirement age. And there's no younger generation coming up below us to be able to replace our positions out there in the fields that we are working in currently right now. We'll have to bring them in all from the lower 48, and you already know what kind of a mess that is here in Alaska, watching our wages that should be staying here going to people that don't even live here. So now we've got these two bills, SB 14, that has incorporated HB 22 into it. And why did I go through all of this to explain this? Tomorrow at 3:30 in the Senate Education Committee, they are taking public testimony on SB 14. Please call in, testify. Get on the list. If you can't call in and testify, I will do my best to make sure that the links to send the email to the Senate Education Committee for SB 14 is there in my what I write up on the top of the live video feed, I will be live with that tomorrow for the testimonies. I am going to try to call in. Hopefully they don't do like they did with SB 52 on Wednesday, the base student allocation, and only leave us with about 45 minutes of giving public testimony. Closed it out 6 minutes early. They still had 6 minutes on the clock. They were supposed to go until 5 o'clock. They cut off testimony. Why? Well, my best guess is by the time that they got to where they were at, I was the next one to testify, and they didn't want my testimony on public record that everyone could replay over and over and over again. But watch my video of those testimonies on Wednesday and at the end, and you'll get to hear what my testimony was on that, so I don't have to repeat myself now. So again, thank you guys all for being here once again. Go to our website, politadick.com, and click that support button. And as always, you can find us live on Twitter, YouTube, Facebook at Politadick and Politadick Unfiltered. And most of our live videos will mitigate over to Rumble at rumble.com/Politadick. And I emphasize that word right there, rumble.com/Politadick, because I need you guys to go there and subscribe. The quicker, and click the bell to be notified too. The quicker we reach to 100 people subscribed over there, we'll be able to live stream directly to Rumble. That way we don't have to pay those exorbitant fees that they want to be able to do that. If we get enough subscribers, we can just go ahead and start streaming to them automatically, and you won't have to wait to find it on Rumble. Find us one less place that they can cancel us, and we will be able to do unfiltered and uncut, which Facebook and Rumble, or Facebook and YouTube, I should say, always seem to want to censor our videos from time to time, either for copyrights or in YouTube's case, they always like to say we've broken their policies for YouTube and gave out some sort of misinformation, but never get flagged by Twitter, and we almost never get, I should say, we've never been flagged by Facebook for misinformation from any of our videos. It's always just YouTube. And so once we can get ourselves on Rumble, we don't have to worry about those videos ever being censored. They will be there to be able to watch and not be banned and removed because of the oligarch big tech think they're the ultimate gods and can decide what can be seen and what can't, what you can hear and cannot hear. They are the overlords. Bow down to them. All right. Thanks again for being here tonight. Appreciate you guys all, and have yourself a great